Joe Henshaw here again, your friendly local constitutional coop from California. And a new video here talking about 'cause so many people today are facing evictions, homelessness, repossession of their property, by HOAs in particular, landlords, corporate landlords. And you instinctively know that none of it's right. It can't be right. If we have creator endowed inalienable rights, and that's what we're supposed to have in a federated republican form of government of defined and limited powers. Then they can't come in there and do this because we have the right to not only judicial court from day one, but trial by jury according to the courts of the common law. And you ain't ever going to see either one of those. And yet, think about this. The Supreme Court has ruled that there must be a voluntary, knowing, and intelligent waiver of rights. Johnson v. Zerps, 304 U.S. 258. You haven't made one. There is, if there's a written agreement, if there is one, it's void because, the HOA and or landlord or whatever failed to make a full disclosure of all the terms of the agreement. And as you'll learn by coming into possession of my constitutional defense document packet, a very modest price for that. There's no jurisdiction at all in any quote unquote state court. And they're all administrative tribunals today, not judicial courts. And with this kind of leverage, we can get a lot done in a hurry here because, given what's going on with the U.S. Supreme Court, as I've talked about, and with the election results and Trump, he's seen back in office, and now that court's going to be there for 10 or 12 years and maybe more than that. And they know exactly what I'm talking about, as they're in their fifth term of an all-out assault on the administrative state, sounding more and more exactly like me in the process. And that's leverage we have against idiots, because if they make a decision on the record, and I don't know if that will come in this term, but they're ready to hit the pedal to the metal here on a lot of issues. And if that happens, it isn't just their case. That's every eviction from Portland, Maine to Portland, Oregon. And it puts these corporate bastards out of business. And that's exactly where they should be. And they might be damn lucky not to be adjacent to cell 2455 in San Quentin on death row. And the same applies to those back road bastards they force you to deal with at any state bar attorneys. And they'll all have titles of nobility, Joe Jackass Esquire, and this, that, and the other. You'll find out that they're also unregistered foreign agents of at least the City of London. And none of them has any standing in the judicial court. Those are the issues you need, not a BS due process of law, equal protection, 14th Amendment crap, and you'll learn so much about that 14th Amendment. And well, the problem they're going to have there, and by the way, I'm just embarrassed it took me this long to do this, but when you acquire my modestly priced CDCP materials, you're going to get one or maybe two personalized short videos that you send to the attorneys for these jackasses, and maybe the presiding judge, and maybe the governor, pursuant to his sworn duty to see the laws are faithfully executed, a major flashpoint in the U.S. Supreme Court recently, and it will continue to be. They have no case. And they know the cases. There's some vintage cases that I use. Collins v. Virginia is a big one. And responding to my video here, you'll get some bonus documents, and you read some of these quotes out of Collins. And yeah, it's 200 years old, but these justices know it, and they know it still applies. That's what's exciting here. First time in 90 plus years, the Supreme Court is acting like a judicial court, which is exactly what we need them to do. So it's just all good news from here on all of these fronts. And it makes sense. I mean, we have personal, creative, endowed rights. Corporations have absolutely zero. You're going to find out even if they have an LLC, and even if they're registered somewhere, they're registered with the Federal Insular Territorial Secretary of State, while you and I are domiciled in a state judicial district. And they can't come into our judicial district to service the process. If they can't make effective service, they can't even get you into court. It's called the Penoria Rule, the U.S. Supreme Court. You'll learn about that too. Penoria v. Neff, 95 U.S. 714. So you make these arguments up front, and now with the neutral magistrate that Supreme Court says has to be there, that's Toomey v. Ohio, 273 U.S. 510. If they haven't proved jurisdiction, even without the direct challenges that we will be making, that magistrate's required to throw it out. Maybe without prejudice the first time, but if they come back and refile and do it again, that's with prejudice, and the case is over for all apparent intents and purposes, and should be. That's the Republican form of government of defined and limited powers, not today's much ballyhoo or democracy, 3 wolves and 2 sheep voting on what's for dinner, aka elected despotism. And the Supreme Court knows all of this. I'm just waiting for a quote-unquote appropriate case, and I can translate there. I know what the code is, and I know how to do that. And that should scare the shit out of these bastards on the other side, because as corrupt as that system is, the court's going to have sooner or later have to decide, hopefully before the end of this term, what do we have? Do we have the Constitution for the United States, 1787 to 1781? Or do we have the 14th War Amendment and the federal regional martial law with which it runs on? And they know the answer, and they knew it back in the day, too. They ruled the 14th Amendment unconstitutional contemporaneously. And that's what we want them to do now. And you'll learn we have every right and reason to expect that to happen. I mean, we're the ones, those racist founding fathers ordained and established this Constitution to secure the blessings of liberty to ourselves and our posterity. Not Chase Bank, not IBM, not J.P. Morgan, none of them. We have rights. They don't. You understand that simple concept? And we can go a long way and in a lot of different areas here, because the whole system functions on this nonsense. And it has since at least 5:01 p.m., July 28th, 1868. And yes, I can talk a cappella like this and tell them to bring on any of their damn attorney they want to bring on. I'll shut them down like I did in my South Carolina felony case. You'll learn more about that with the acquisition of my materials, what I did there. And that's $1 million video if I had it. I shut them down in 90 seconds flat. In a felony case, it never got further than that because they couldn't prove I was crazy and they couldn't prove I did anything wrong. And yet I got transported 3,000 miles across the country. Well, it's a long, interesting, funny, and the final analysis story. But I have that kind of talent. We're going to get a bonus video or two to introduce these people on the other side, 6 or 8 minutes. And I'm going to invite them to do it because we're going to demand trial by jury, and we're going to have jury instructions, and that's going to end the matter. It has to. If we get to a common law jury, they don't even have standing there, but we do. Wow, that's how good a job they did back in 1787 to 1791. And no, it wasn't a perfect government. But the big deal is, and it doesn't matter, by the way, whether you're Asian, African, American, whatever, because we all have rights. We get back to where we were in, say, 1855. You're not a member of the sovereign body politic if you're Asian or African, but you sure as hell weren't then either. And I think world history supports the view on that subject. But what you did have was creator endowed and alienable rights that you could enforce. And what that means in a nutshell is you can't get these state law enforcement thugs in Akron, Ohio that went out there and shot Jalen Walker in the back 48 times during the course of a traffic stop where the traffic court wouldn't have had jurisdiction. And none of these bastards gets indicted for even involuntary manslaughter when they should be on death row. By working together, we can make that happen a whole lot more quicker, and it's going to stop it cold. And there's more to talk about on that issue later, which I'll be doing. But that said, send me an email, uwincourt@gmail.com, for information on my materials and how to get started. And we can go from there. And remember to tell your friends, like the videos, get the word out. The quicker we take action in this miraculous window of opportunity, the sooner America gets better and in a hurry. Thank